Hey, Colby here, and welcome again to Hold My Briefcase, where we talk about small legal matters, small legal education. Scratch that. Hey, Colby here, and welcome to Hold My Briefcase, a podcast that's designed for you to learn the secrets and ins and outs of the little tricks that lawyers can use day to day and learn about the legal world and how you can use that in your daily life in order to advance and get what you're entitled to. My name is Colby Lewis. I'm the managing partner of the law offices of Colby Lewis. I've been doing this for 20 years, and I am very happy to be able to share some of this knowledge I've gotten with people over the years, from people over the years. And today I want to talk to everyone about what's called discovery. And you might hear this term being thrown around a little bit. So when you file a lawsuit, right, you might not know the full extent of what's going on with that company. Say, for example, you filed a lawsuit against. So you aren't privy to their internal memorandum, their emails, the phone calls they had, the warnings they may have gotten that are in their file. You don't have any of that information, right? And similarly, the other side doesn't know about you. They don't have your medical records. They don't know what kind of person you are. And so, in order to figure out what the case is about, the parties conduct what's called discovery. Now, what discovery is almost exactly like it sounds. One side is discovering the facts of the other side. And this is important because under Texas rules, and actually under the federal rules of civil procedure as well, which the Texas rules were modeled after, the case is supposed to be tried not on what is revealed and not what is concealed, right? And the old adage is that you can't lie behind the log, right? You can't have trial by surprise. You have to let everyone know this is what you got, this is what you're going to say, and this is what supports what you're going to say. And that might be bad for the surprise Sherlock Holmes moment. I'm sorry, or the lawyer uh, attacks and says, "Oh, I've got this, and let me see this magical thing right here, and I've got the smoking gun." Well, if you try to do that in a real court, real case, it's very likely that the judge would call you to the bench, admonish you for not asking permission before bringing it up, and proceed to exclude the evidence from the case, even though it might be relevant because you didn't disclose it ahead of time, right? Because you didn't reveal the magic bullet you have, the smoking gun you have. You can't use it at trial. It sounds kind of insane, but that's the way the system works. Now, of course, there's always exceptions to the rule, and that's why rules are created. But for the most part, you are supposed to discover all the facts about the case. And the reason for that is because, again, the law prefers keeping you out of the courthouse. And in fact, you conduct discovery completely away from the court. You do not go to court. You do not file the discovery responses with the court. You do not put the discovery requests through the actual e-service. It's just documents exchanged between the attorneys. And there's lots of different types of discovery, but there's basically two categories actually. And the first category is deposition testimony. And that's what you see on television when somebody goes into a little room and the court reporter's got a little thing and they're talking about, what can we do? And, then you get a transcript, and that transcript is admissible in a court of law, just like if you were there yourself. And then you have the what's called written discovery. And written discovery is exactly what it sounds like. It's written. It's transferred from one attorney to the other, from their attorney to your attorney, and it has various requests on it. For example, there could be a request for production, which is a request to produce documents or tangible things. So produce your medical records, produce a redacted copy of your driver's license to prove that you were licensed to drive at the time. The other side, produce your insurance policy and produce your safety records, produce the prior reports on safety that have specifically been involved with this situation. Now you start to see how the case can unfold. The company will give you the documents. The documents say they did something wrong. You say, hey, look, you produced these documents that say you did something wrong. You are liable. You need to settle. Right. And the idea here is that everybody knows if you've done something wrong, you can be held not only for, your valuation at the time, but, maybe the jury gets mad at you. Right. And maybe they get you for more. And so along along the lines somewhere that when we're dealing with these cases, discovery became almost more important than trial because, if you're settling 99% of all cases, which needs to happen because there just simply isn't enough room for the settlement for all the trials to occur in any courthouse, even in Harris County. Um, Without that throughput, without the ability to try lawsuits, then the only recourse to get money timely or to get the value for your case is by putting up a great case on paper. There is no doubt on liability. There is no doubt on damages. Here are the medical records. Here are the videos that we got. Here's the deposition testimony that Colby got where your employee admitted he messed up and admitted you didn't train him. Right now, that's a lot different than, hey, our client was hurt. They shouldn't have been hurt. You did something wrong. That's completely different. And so it is an approach that's necessary in order to get to the root of what is the lawsuit, to find out why we're here and to find out what evidence out there is to support it. Because if there is no evidence to support the claim, then the other side can move to dismiss. After a sufficient time for discovery, if you haven't dug anything up, then your case could be over. And as you can see, then it becomes a struggle, a fight over, hey, you didn't give me this. You owe me this. You're supposed to produce this. You didn't produce this. A little game of cat and mouse. And sometimes the defendant likes to hide things. And so the plaintiff's attorney has to go in and compel them, force them, get a court order to get them to produce discovery responses. We don't want to produce our past safety reports. Oh, they're confidential. Well, let's go talk to the judge. Because they're not so confidential that you can hide behind confidentiality when it comes to hurting people. And, you have that happen a lot where, people try to use their policies, right? Well, we're sorry. Well, we deleted that email. Oh, isn't that interesting? Well, your company retention policy says you're supposed to keep everything for 2 years. So it looks like you intentionally destroyed this. Let's go talk to the judge about that, right? It is unfortunate that we live in a world today where some people would rather pay their attorneys than do what's right. And so a lot of cases get bogged down in discovery. It can take hours to file a petition, and it can take years to get through discovery. And then the mediation can happen in one day. So the full corpus of the case, the full body of the case, almost the entire life of the case is in discovery. Scheduling depositions, taking depositions, sending written discovery back and forth. Each one of those has a timer and a timeline and a deadline that each attorney has to follow. So over time, in drips and drabs, the facts of the case come out. And then your attorney will pick up all those facts and put those together into a demand. And then that demand is what they will use against the insurance company in order to make sure that you get reimbursed the harms and losses that you've gone through because of the negligence of another or because of the insurance company not doing what they're supposed to do. Now, discovery is just one phase of litigation. There are many, and this is not even a very in-depth discussion of it. This is just quick talk, give you some guidelines, give you some ideas, and get you to start learning some of the terminology that we as lawyers use on a daily basis, whether it be a depo, an RFP, a ROG, a RFA, all these things we can get to, and we're going to discuss at a later date. But today I wanted to get you through what discovery is. Discovery 101, what you need to know about this phase of your litigation. My name's Colby Lewis. This has been Hold My Briefcase, where I talk to you about issues and ideas and knowledge that you can use in your daily life to help you. Thank you.